There's a question that I get asked pretty frequently about climate litigation. Did litigants actually win anything? And I get why people ask this. But impact isn't just about winning or losing. It's about how litigation reshapes policy, politics, and public understanding. Let me share what I've learned from studying the real-world effects of this legal transformation. Traditional analysis focuses only on direct policy wins. I propose looking at 4 types of impact. First, we have direct material effects. These are the policies that courts actually order. Then there are changes in perceptions that I call direct symbolic effects. It has to do with how litigation reframes climate change. Third, we have indirect material effects, like movement building and political ripple effects. And then finally, indirect symbolic effects, indirect changes in people's perceptions, like the shifting of public opinion about climate change. When I interviewed climate litigators around the world, many told me that their primary goal was not necessarily winning specific cases. It was putting a human face on climate change and creating pressure for systemic change. Let's start with the clear wins. Some cases do produce direct policy changes. When Germany Constitutional Court ruled in favor of young climate activists in 2021, the government responded within weeks. A new climate law was passed. Emissions cuts were increased from 55% to 65% by 2030, and 8 billion euros in new funding allocated. I had a chance to document this impact in Brazil. When the Supreme Court ordered the government to reactivate its frozen climate fund, results were truly dramatic. The fund went from 17 months without meetings to a record 10 billion reais in new commitments under the new administration. But here's the reality: compliance isn't guaranteed. Shell did not fully comply with the lower court's order in the Netherlands, and the reversal of the decision by the appeals court made the issue of compliance moot. But perhaps more important than specific policy wins is how litigation has reframed climate change itself. Remember when climate change meant polar bears on melting ice? Litigation puts human faces on climate impacts. Young people with climate anxiety, elderly women vulnerable to heat waves, indigenous communities losing their land. As one litigator told me, we're not talking about polar bears anymore. This reframing has been massive. Brazil's Supreme Court now views climate treaties as human rights law. Courts worldwide routinely describe climate change as the greatest human rights challenge of the 21st century. And some of litigation's most important effects happen actually outside courtrooms entirely. The Swiss senior women case galvanized the climate movement across Europe. Brazil's climate litigation community grew from a handful of organizations to more than 50 groups collaborating nationwide. They are one of the most vibrant and creative collectives in this field. Youth climate cases inspired movements from Germany to Bangladesh to Mexico. I witnessed this transformation firsthand at COP28 in Dubai in 2023. 20 years earlier, at COP9 in Milan, Sheila Watt-Luthier had to organize her climate rights presentation in side rooms. Now, at the heart of COP, Supreme Court justices from Brazil to Kenya were confidently discussing climate change as a fundamental human rights issue that required decisive judicial action. But the deepest impacts may be the hardest to measure: how litigation shifts public consciousness. Many cases actually function as teach-ins. Brazil's Supreme Court held 2 days of public hearings on climate science broadcast live. The Philippines Carbon Majors Inquiry explicitly aimed to, quote-unquote, laymanize climate justice for ordinary people, in the words of one of the activists that we interviewed. The International Court of Justice held 2 weeks of public hearings in late 2024 in preparation for its advisory opinion on climate change. Litigation has fundamentally altered how we talk about climate change, from an environmental issue to a human rights crisis, from future problem to present emergency, from abstract science to personal stories, from collective responsibility to individual accountability. Not all impacts are positive, of course. Success sometimes triggers backlash. Switzerland's parliament rejected the European Court's climate ruling, declaring it inadmissible judicial activism. In Canada, the UK, and elsewhere, some governments and companies have filed lawsuits against climate protesters. After studying 467 cases across 20 years, here's what I've learned about impact. Litigation works best as part of broader political strategies, not as isolated legal actions. Symbolic impacts often matter more than direct policy wins. Cross-border learning accelerates when litigators share strategies openly. Unfortunately, the biggest gaps remain: adaptation, climate compensations, and corporate accountability. We are truly at a critical juncture. The Paris Agreement framework is failing. Rights-based climate litigation can help close the accountability gap, but it is not by any means a silver bullet. There is no silver bullet for climate change. Litigation should be seen as a useful tool in the broader toolkit of climate governance. The question isn't whether litigation can solve climate change alone. It can't. The question is whether we'll use every tool available, including law and rights, to accelerate the transformation our planet badly needs. As we look towards the future, some key questions remain open. How will we protect the rights of the millions more people who will have to relocate as they run away from heat waves, droughts, floods, and other extreme weather events? Will litigation fill the gap of climate justice when it comes to compensating the communities and countries who are most vulnerable to global warming and yet have contributed the least to the crisis? Climate litigation also reveals important lessons for the future of human rights itself. They prove that human rights remain remarkably adaptable. Courts worldwide have stretched traditional concepts of standing, causality, and state responsibility to address planetary-scale challenges. They've developed forward-looking interpretations of human rights that complement the usual backward-looking accountability model. This experimentation feels hopeful. It offers hope for addressing other Anthropocene crises, from biodiversity loss to toxic pollution. These videos capture key insights from my book, Climate Change on Trial. For the complete analysis of how human rights litigation is reshaping climate governance, including detailed case studies, legal doctrines, and impact assessments, I encourage you to read the full book.